Good afternoon, everyone. It is 2 p.m. Eastern Time. My name is Michael Lewis. I am the Vice President of Policy at the American Association of People with Disabilities. Thank you all so very much for taking the time to be with us this afternoon as we dig into the new Medicaid work requirements that are scheduled to launch January 1 of 2027, just about 5 months from now, 4.5 months. Um, it is 2 o'clock, so we'll go ahead and get started. This webinar is being recorded. It will be recorded and then we will have it captioned and we will send it out via email to everyone that registered for the webinar. So if you can't stay for the entire hour and a half, it will be recorded and sent to you within the next week. A couple of housekeeping announcements. We do Jason and cart if you need it. So if you need cart on the bottom of your Zoom screen, there will be a button that is all the way in the center, but on the right hand side, it's a little circle with 3 dots in it that says more. Click on that, and a menu will pop up, and you will see a closed captioned icon that says show captions. If you click on that, you will be able to see the captions. Also, we will drop a link to the stream text in the chat box, but please do not use the carry on conversation during the webinar, as that can be distracting, and those who are vision, have low vision, or who are blind often cannot see those. So if you do have a question that you would like to submit for a panelist, go back under the More button and you will see another icon that says Q&A, and we invite you to submit your questions via the Q&A feature, and we will get to as many questions as we can in the second half of the webinar. Again, thank you so much for joining us. I am Michael Lewis, VP of Policy for AAPD. For a brief visual description, I am a white man with short blonde hair, rapidly approaching middle age, wearing a coral-colored polo shirt. Today we are joined by 2 panelists, the first of whom is Rachel Patterson, who was with Patterson and Meek. She is the partner in a disability and healthcare consulting firm and policy firm in Washington, D.C. She previously worked um, the disability policy advisor for the White House Domestic Policy Council under the Biden administration. So thank you so much for being here. And we are also joined by Jennifer Lab, who is the director of the Disability Practice Area for the National Health Law Program. So without further ado, we're gonna jump into our program here. But as I call on you the first time, if you could give a brief visual description of yourself before you answer the question. So, the first question is for Rachel Patterson. Um, to get it started, we know that the Center for Medicare and Medicaid Services released an interim final rule back at the beginning of June regarding the new Medicaid work requirements. Can you briefly explain what an interim final rule is and why this one is particularly concerning?
Sure. Thank you, Michael. And again, this is Rachel Patterson. For brief description, I'm a white woman with black hair, wearing a blue button up, and I have a green background with my company logo on it. Um, so, what is an interim final rule? When Congress passes a law, they often provide broad outlines of what they want the program to look like. And then the implementing agency, that part of the federal government, has to write the rules. What is it really going to look like? They go through all of the nitty-gritty details. Most often, they do that through a proposed rule, and then everybody in the public can comment on it. Me and Jennifer and Michael spend a lot of our time doing this. They take into account those comments and then they put out a final rule describing the way things are really going to work. For the Medicaid work requirements, Congress said, you don't have to do that. You can just go straight to a final rule. And that's what they've done here. So they call it an interim final rule because they are accepting comments on it, but they don't necessarily have to take those into account. And the rule they've written is what will take effect. So this one is concerning to us because Congress told them they don't have to take our input. Now, we're going to talk later about why we should all still write comments because that's important. But they are moving forward with sort of their draft, their version, without our input. And that's something we find really concerning for a lot of reasons that we'll get into, especially with how much of an impact this is going to have on people with disabilities and their choice to move forward without our voices included.
Thank you, Rachel. The next question is for Jennifer. What does the term work requirement, or as it says in the statute, community engagement requirement, what does that actually mean? And what if you don't have a job? Are there ways that you can meet those requirements if you do not have a job that you go to for pay?
Yeah. Thanks for that question, Michael, and happy to be here. I am a white woman, middle-aged, short, dark black hair. I'm wearing a white collar shirt and a black jacket, and my background says National Health Law Program, and it's blue and shades of blue and white. So thanks for having me here today. And that's a great question. The definition of the first thing I want to say before we dive into this is not everybody's going to have to comply with this work requirement. And I know we're going to talk about that more later on. But I just want to note that off the bat. But when they are talking about the work requirement, if someone needs to comply with it, they're going to be able to fulfill what they call in this rule the community engagement requirement by several different ways. The first way is by showing you're working 80 hours a month. The second way is by engaging in 80 hours of community service a month. The third way is engaging in an educational program, half-time, or any combination of those three. Another way you can prove it would be by having your income be at least minimum wage for 80 hours a month. So in 2026, that's earning about $580 a month. Or for seasonal workers, right, who don't get that every month, it could be their average monthly income over 6 months is not less than that 580. So there's a lot of different ways in which people can show that they're meeting these community engagement requirements. And then doing a deeper dive into what does that actually mean to be working. That isn't just, your average job where you're getting a wage. It could be paid or it could be unpaid work. It could also be work in kind. So, sometimes people have jobs where they might work in order to have a place to live or to, they might trade, for some goods or services of that kind. It could also be a work program is another way, right? So it's not just any work program. It can't just, but some work programs, if you're enrolled in it, that could be a way in which you could comply. So there's several different ways that you could comply. People will have to demonstrate this at the time of application for Medicaid. So it would be at least 1 month prior to application, but no more than 3 months. And that depends on what state choices. But all states where this applies is they're going to have to show that to demonstrate that you're complying 1 month prior to application. And then once you're enrolled, you're also going to have to show that you're complying with it. So it's a front door requirement and then an ongoing requirement as you go on.
Thank you, Jennifer. Right, so the next question is for you. Will people with disability be exempt from these requirements? And if so, how did that happen? Did that happen automatically? Did you have to go through a process? Can you tell us a little bit about what that looks like and what people might have to have ready so that if they need to, they can prove that?
Yep, absolutely. So when talking about whether or not people with disabilities are exempt from these requirements, the answer is sort of both yes and no. And that's going to be really confusing and it's going to be complicated. So I'm going to apologize in advance for that. But I will also say one of our concerns with this program is its complexity and the extent to which it's confusing. And if you're on Medicaid, it's already pretty confusing. So let's start with yes. Let's start with when people are going to be automatically excluded or exempted. That's if say you're on Social Security, supplemental security income, and that's how you get Medicaid. That is your we call it a pathway. That is the way that you are signed up for Medicaid. This program shouldn't affect you at all. I'm going to put a big asterisk on shouldn't because there's going to be some paperwork confusion. Again, if you're on Medicaid, you know about this. But per the rules, this shouldn't affect you. Anyone under the age of 19 shouldn't be affected. Then you start to get into times when you could be affected, but you qualify for some kind of exclusion. So I think a great example is people who have a disability determination from the Social Security Administration. veterans who have a total disability determination from the Veterans Administration. In the VA, there's both the like total and partial. If it's a total disability rating, then you're exempted. They also wrote an exemption for anyone with a physical, developmental, or intellectual disability that affects one or more activities of daily living. That might be a term you've heard before. It includes like getting dressed and going to the bathroom and sort of those daily activities. And then finally, they wrote one for people with serious and complex medical conditions. So those are folks who should be able to say, oh, I have one of these conditions. I don't have to meet this requirement. But there's two complications to that I want to talk about. One is, how do you prove it? So if you have your VA paperwork or your Social Security paperwork, okay, that's good. You've already been received that from another agency. If you have a serious medical condition, now we start getting into documentation from a doctor. That can be pretty hard to obtain. So we're already going to have a problem with proving that you have this condition that means you should be excluded. And then CMS has added another requirement that you also have to prove that that condition or diagnosis significantly impairs your ability to comply with this community engagement or work requirement. We're going to use both terms interchangeably. That is going to be hard to do. And it's one of the things that a lot of us are focusing on right now is how do you expect people to do that? And I wish that we had better answers for all of you who are on this webinar, but I also want to be honest with you about what we know and what we don't know. So right now we know that CMS has added this requirement, and we are working very hard and pushing them very hard to say, you got to tell us more what this means. And also working with the states to do the same thing when they are putting together these programs to make sure that people who should receive those exemptions actually do. So to wrap this back up, when we say are people with disabilities, sort of automatically exempted, sometimes, yes, sometimes it'll be automatic. You won't even know. Sometimes you will have to provide some kind of paperwork, some kind of explanation. And in some of those cases, we are not totally sure yet what it is your state's going to need. So again, I don't like coming on here and having uncertainty, but I also feel like we should be honest.
Thank you, Rachel, very much for that. The next question is for both Jennifer and Rachel. Can you lose Medicaid even if you do qualify for an exemption? And if so, what do you do in that case?
I'm going to start and then turn it over to Jennifer because the answer is yes. Either you don't get a notice in the mail, you miss something, you aren't able to get a certain type of paperwork. One of the things I have said to people when this law was even being debated, I would say, how many of you absolutely check the mail every single day and open every piece of mail and take action on it immediately and do it perfectly every single time? That's not how human beings live. So there are going to be times when those types of things happen, or the state makes a mistake. You do it perfectly, but the state makes a mistake. So I'm going to send the harder part over to Jennifer to talk about what is your recourse?
Yeah, I think I also wanted to just reiterate and underscore what Rachel said with some examples. Right? Like, so this shouldn't happen, but this does happen, and it's one of the reasons why we're very concerned with this change. Because there's always people that should be eligible for Medicaid that don't get it. And just some examples from history, like we know every time there's been major eligibility changes, historically it's led to dysfunction and harm. Um, and there's like no magic sorting hat out there or single computer system that like states can just query and say, oh, this person should be or shouldn't be eligible, especially under this new system that they're setting up. And when the Affordable Care Act was implemented, if anybody remembers that, right, it was passed in 2010 and wasn't implemented until 2014, right? And that was one of the biggest changes in Medicaid, where they had a whole new category, this Medicaid expansion category, that now covers about 20 million people. And I don't know if anybody remembers 2014, but if does anybody, there were website crashes the day it launched. There were backlogs to enroll in expansion that were hundreds of thousands of people long, and they had years to prepare for that. And here we're having states make very drastic changes in a much shorter period. 1 year, the law was passed a year ago. This interim final rule with comment period comes out 6 months before it takes effect. So we just know from past experience how difficult this can be. This also happened at the end of the public health emergency for COVID when the government said the emergency was over. They had to redetermine eligibility very quickly. States did for a lot of people. And we know that almost 70% of the people that got disenrolled for procedural reasons. So those are exactly what Rachel was talking about, the mail that didn't go to the right place, or the person that didn't answer, or the person that got conflicting information in the mail, the wrong notice. There's, that happens to people. They can get, two notices on the same day. One says do this, one says do that. That's real life examples. So that is sort of what is at risk and how people can lose eligibility, even if they should qualify for an exemption or exclusion, as Michael said. And that's one of the reasons why it's really important that states figure this out as much as they can on their own without having to ask people to submit additional paperwork. There's a fancy legal term, ex parte, for that. But really what it means is the state uses the information that they have to try to figure this out and don't put burdens on people. So that was a long-winded answer before getting to the part that Rachel asked me to cover, which is what do you do? I think that, we were going to talk about this a little bit later too, but there's a lot of things that you can do if you lose Medicaid, or you get told that you have to meet a work requirement when you don't. I mean, before anything, I would say you got to keep, if you can, keep your address and contact information up to date with all the agencies, and especially the Medicaid agency, so you get those notices. The second is to open the mail. I know that can be hard to do and stay on top of. I've had family members that get benefits, get Medicaid, and it's constant, it's daily, and you're like, what do I do now? But it can be overwhelming. But, note the dates to reply. Sometimes there's quick turnarounds. I would keep envelopes for postmark dates if you get things physically through mail. If you're told wrongly that you something that you don't think is right, I would look for problem solving opportunities like helplines, resource centers. There's advocates in every state that want to help people with this. It can be really hard to get through. We sometimes hear when these things roll out, long wait times for help, inaccessibility when you try to get that help, in terms of call centers and things like that. But if you can document where you have trouble, stick through that, try to get through, request accommodations, make a record of that. And if not granted, ask for a way to appeal that. Document everything. You make a call, you make a note of it. Right? You make an accommodation, you make a note of it. And then the last thing I would say is that nothing in this rule changes basically people's underlying procedural rights in Medicaid. And what I mean by that is that if you get a termination notice, you can still ask for a hearing. You can still challenge it the same way that you could challenge things before. You can still challenge. And we have a publication on that, on what people's due process rights are related, and notice rights are related to work requirements that I'm happy to share out.
Thanks, Jennifer. Just a really quick follow-up to that. You mentioned um, ex parte and states using existing data. So what does that actually look like? Like if you get SSI, the state should know that, correct?
They should be able to query that, is my understanding, yeah.
Okay. This next question, thank you, Jennifer, is for Rachel. Um, will caregivers be exempted, whether it's caregivers for children who are in school or disabled family members? There's been a lot of concern about that.
Yes, there are exclusions for caregivers, both if you are the parent of a child under age 14. And again, that hopefully is data the state might have and be able to do automatically, not necessarily, but hopefully. There's also one for if you are a caregiver of a disabled person of any age. And here they use a very broad definition of disability. And here's a little thing that's weird. The definition of disability that they use for the caregiver, so the disabled person they're caring for, is different than the one they use for if you are disabled and getting an exclusion on your own. So right now I'm talking about the caregiver. They do a very broad definition of disability, which is good. We want that because we want more people to not have to meet these requirements in order to maintain their health coverage. So we've got you're caring for a kid under age 14 or a disabled person of any age. And then there's what does the care entail? And they include if you are related to the person, or if you live with the person, so you can live with them and not be related, or be related and not live with them. They also include if you are not related and don't live with them, but provide 80 hours a month of that caregiving. If you are providing caregiving less than 80 hours a month, you can actually combine those hours with, and again, this is only if you're not related and don't live with them. You can combine those hours with the other things that Jennifer mentioned earlier, like working, volunteering, that kind of thing. Where things get complicated again is the paperwork. How are you gonna show it? This is a system that states are going to be developing on how they want you to show that you are providing these hours. It's easier to show if you live in the same house as someone or if you're related to them. It's going to be harder if it has to be hours based, but those exclusions do exist, and we hope that they'll apply to a lot of people.
Thank you so much, Rachel. Jennifer, this next question is for you. We know that the rule gives a leeway to states in a lot of different areas. And so we know that these requirements are going to look different state to state. But and how they determine exemptions and stuff like that. But overall, how are they assessing eligibility so far? Do you know anything? Have you heard anything about whether states are primarily viewing this broadly? Are they looking at it through a very narrow lens? What do you know, if anything?
Um, so this requirement takes place in about 5 months, right? I think, if I'm counting right. Um, and up until last month, states were given some indication from CMS that CMS was going to go in a pretty different direction and not have this um, requirement that people show that their special medical needs or medically frail, as people have been calling it, significantly impairs their ability to comply with the work requirements. So up until last month, we started seeing states, coming up with lists um, of sort of conditions and disabilities that they thought might meet the definition and would exempt people. And then we got this interim final rule. And states are now going to have to assess whether the condition significantly impairs an ability to comply with the community engagement requirements, at least according to this rule. And we are not I am not seeing yet really a lot of information come out as to how states are going to do that, because this was our understanding is that they've been going down one path and they've received some information that that would be the way to do it, and now they have to change direction a bit. What I do know is that 25 states and DC did file a lawsuit. As they describe it, they said that this interim final rule has caused chaos for the plaintiff states, making it exceedingly difficult to comply with these deadlines that are coming up. And they asked for what's called a preliminary injunction. They asked for a court to stop this. So, and they asked for an extension of time to come up with policies to comply with this. And part of the reason they did this, one of the things they were challenging is the requirement that medical frailty or special medical needs is limited to those whose conditions significantly impair the ability to comply, and some other things. Right? So I say all this to say things are very much in flux right now. And I don't have a lot of detail that I can point to as to how states are going to try to implement this. We do know there are a few states that want to implement this early, Nebraska and Montana, and I think Arkansas did a soft launch of this. But even those states are still not at the place where they have started to disenroll people. So it's very much a watch and wait now, to try to see sort of we know what the expected impact is and very concerned about it. But the information on how states are implementing this is still coming out.
Thank you, John, for this last question earlier for both of you. What is the best way to prepare for major changes in health insurance? Are there documents that you should be gathering and putting in a folder where you can get to them easily? If you were wrongly told that you have to meet the work requirement, I know that states are supposed to send out letters as early as September, letting people know that this is coming up. What do they do when they get a letter that says you fall within this, and it's wrong? What is the best course of action between that initial letter and the January one?
I'll start by saying, hold on to your paperwork, be it from Social Security, your state agency, the VA, your medical records and documentation, anything that you can have on your own, especially anything you get. It is very challenging to get documents out of a major medical system. So anything that you do have, keep yours. I definitely do that. I make sure that I have everything in my possession. That would I think would say be the first step is hold on to the documentation that you have, and anything new that you get, hold on to that as well. Jen, do you want to talk about if they get the notice?
Sure. I mean, there's different kinds of notice that people might get too, so it might be worth understanding that. The first kind of notice that people will be getting is outreach notice that is required. So the state's outreach notice has to include things like how to comply, describe some of these exemptions, who's subject to the requirement, and that's supposed to come out 4 months prior to implementation of the work requirements. Um, and so that is just information that they have to send out, and they're supposed to send it out to people who could be subject to it. Um, the second is if the state can't verify compliance, so they'd send then a notice of non-compliance. And it would say how you can show compliance, and they should give you 30 days to show that, right? So those are ones to watch out for and to be sure to reply to, because you might have that information that Rachel, suggested that you collect, and that would be the time to share it. And then the third thing is a notice of what's called adverse action. And that's when they say, we're going to take this action to end your Medicaid or something like that. And when that happens, you have an ability to challenge that decision, and there's certain timeframes to follow to do so. And it's important to um, be aware of that, to read it, and to follow up and to seek assistance if you need assistance from an advocacy organization at that point. Um, so I think that that's something to be thinking about in terms of preparing, just knowing you might get different kinds of notices and how you can respond to those. But otherwise, I would say the same things that we said before about being sure that your address is up to date, that you know how to get communications, um, being sure that you document any requests that you make, that you know who your state advocates are, and where you can go for assistance if you do run into these issues as well.
Then, in case people do not know, every state has a protection and advocacy uh, agency uh, that works to provide legal help to people with disabilities, and usually the name of that organization has the name of the state in it. So Disability Rights Maryland, for instance. If you don't know the exact name of your state PNA, you can easily find it via Google search. The type of protection and advocacy organization near me, and it's a pop up. The next question is also for both Rachel and Jennifer. What, if anything, can we do now before these requirements start in January? Is there any way to influence or get CMS to change the requirements that they put out in June?
Yes, this is Rachel. I'll start because at the very beginning, I talked about how this is being done in a little bit different way, where they are not taking feedback the way they normally do. However, uh, it is open for public comment. AAPD is already or is going to be running a campaign to help people comment. And it's really, really important for people to weigh in and just tell their side of the story. We are in DC telling these stories, but sometimes people don't believe us. They need to hear it from people across the country. Um, you know, well, first I'm going to say why. Okay. You think this administration's never going to listen to me. That might be true. But these comments are part of the formal record, which means a couple of different things. We've already mentioned that several states are suing the federal government. When we submit comments, it can kind of help their side. They can point to this evidence and say, see, look what all these people are saying. They also stay on the record if, say, a future administration comes in or there's other kinds of efforts to change what CMS is doing. I will say the comments are public, so when you submit them, just keep that in mind when you're submitting information. You can make it anonymous, but don't share things you don't want the whole world to know. But when you share those stories, they really help bolster the arguments of a lot of different people trying to make CMS and the administration and Congress change this program. One thing I want to point out when it comes to commenting is you can also show where they just didn't get things right. And I think a great example is when agencies do rulemaking like this, they are required to estimate how much time it will take. They estimated that it will take people 2 hours to get their documentation together and submit it, which, if you have ever had a major health issue, gone through disability determination, had to get this documentation together, it's almost insulting to think that it would take 2 hours, especially if you need an additional appointment, if you rely on public transportation, if English is not your primary language, if you are on the hold for a long time, if they don't give you what you need right away, if you then need to spend hours, it's inaccessible to you. The number of steps and the amount of work it takes to get your medical records, your disability documentation, that's a place where I think that it really makes sense for a lot of people to weigh in. There's a lot of problems with this rule, but I think that's something where individual people can say, what? 2 hours? Um, where we can show they really have not thought through the impact this is going to have on people.
Um, yes, and I would say I think that commenting is the number one important strategy. So I don't want to be repetitive here. I think that one thing to remember is you don't have to have legal arguments to comment at all. You're an expert on your own situation. And the best strategy is often not to cut and paste something, but you can use templates. They're great as guides on how to do it and support, but share your own story that you're an expert on and how that you think this might impact you. The other ways you could do it, I'm not sorry, excuse me, not other ways you can do it, but other ways to get involved is also that every state has what's called a MACBAC, a Medicaid Advisory Council, and a Beneficiary Advisory Council. And the Beneficiary Advisory Council is a place where people who get Medicaid can participate and have opportunities to get information explained to them by their state and an opportunity to comment or publicly participate. So those are relatively new. States stood them up fairly recently. But look for that in your state. It would be called a BAC, a BAC, and that can be a great way to plug in if you're not quite sure how to do that or how to interact with your state Medicaid agency and you want to share feedback and get comments there. I think there's also a number of state level coalitions and things like that, which I'm sure we can share out if people want to talk more and get more information about these. I mean, Michael mentioned protection advocacy programs. Those are wonderful ways to get involved too, to learn what's happening. And there are a number of other wonderful organizations out there.
Thank you, Jennifer. While we are on the topic of submitting comments, I did want to let everybody know that AAPD will be sending out a comment campaign via email to everyone who was on the AAPD email list. And that will provide an overview of everything we've discussed today as far as what's happening, and then provide you a very easy way to submit comments to CMS, and it will include a draft template comment with highlighted sections where you can personalize it and tell about how this will impact you personally. So those parts of the template are great areas to say stuff like, 2 hours. I can't do this in 2 hours, or I don't have access to the document. Um, those are the kind of things that CMS really need to hear. And we'll have more announcements before we wrap up, but it is 2:45 p.m. now. We are going to take a 5-minute break and come back here at 2:51. So if you'd like, go get yourself some water, go to the bathroom, stand up and stretch. And we will get started with some questions at 2:51. Good afternoon, everyone. Again, welcome back. Um, we are going to dive into some questions, and thank you to everyone who submitted questions in advance. Um, we are going to start with some of the questions that folks submitted before the webinar, and then we will go into some of the questions that people have submitted in the Q&A. So, um, as I read out questions, Rachel and Sarah, whichever of you would like to jump in, feel free to do so. So, number one, do these work requirements apply to Medicaid for disabled individuals who work? Um,
Jumping in with like the
Rachel,
hardest question. Jennifer, do you know? I feel like I'm still trying to figure this out.
Does it apply? Could you say one more time? Sorry, to Medicaid?
disabled people who work.
I'm assuming
So, if
that's the
you,
Medicaid buy-in.
yeah, yeah.
The Medicaid buy-in. So I think that a lot of this stuff, again, we started with this, everybody's working through this rule, right? And I think that the one thing to remember is that this doesn't apply to everybody in Medicaid. So it would depend on what category the person enrolls in as part of it. Right? These are the basic rule for it is are people of who has to apply, who's an applicable individual, right? Are people that are enrolled in the expansion population, right? So that's number one question, right? Which population are you in? Are you in that or a waiver that sort of is similar to that? Um, and are you, eligible to enroll otherwise in the state plan? So there's sort of a system in which you want to go through to determine whether or not this rule, this work requirement is going to uh, um, affect you. Um, and then on top, and then there's also this other, are you a specified excluded individual and how that interacts there? And one might say that most people that are on the Medicaid buy-in have a disability, that would probably fall somewhere in there. But then you have on top of it, it has to significantly impair your ability to meet the community engagement requirement. So there's level upon level, and it's hard to say that that I think that we'd have to look at an individual's um, uh, uh, circumstances and sort of walk through that process in order to answer that question. And then you have this other level on top of it, even if it applies. If you're working, are you meeting the requirement, right? So it is, and I see in here there's comments that buy-ins greatly vary by state. And so I think that it's hard to give a blanket answer to that, but it's as Rachel said, starting with one of the tougher questions there. But that's how I would begin to unroll that, unpack that analysis. And I hope that's not too dissatisfying of an answer, but we have to, work through all of these things.
That is a great segue to kind of a follow up on that. What if you have a disability but you don't get SSDI, you don't get SSI, but let's say you have, chronic health conditions that make it very difficult to work. Will it be harder for those people to qualify for the exemption?
So the question is, if you're not getting SSI or SSDI, but you have some sort of disability, will it be harder to qualify? I think that I think it depends what you mean by harder to qualify. I guess that's not to be a lawyer and answer, and ask for definitions, but I think anybody that fits into a easy box, I hate to say, where the state can sort of ask a database, do you fit this or that? Will make it easier to administer it. The issue is that for some of these, for this medically frail or special medical need exemption that we've been talking about here, the interim final rule says that you have to have a qualifying condition plus a functional limitation plus a significant impairment, right? It is unclear. There is not a database out there as to who has significant impairment to complying with the community engagement requirement. So they're going to have a way to figure that out. And so will it be harder? I don't know. Are there more chances that it won't be automated, that you might have to fill out additional paperwork, that there might be additional barriers? Is there more risk? I would say yes for people in that category.
Yeah, I want to add, I'm thinking especially about people with serious medical issues, who may no longer be working or not working that much. I'm thinking about folks with long COVID. I'm thinking about folks with other energy limiting disabilities. I'm really worried. I'm really worried about maintaining their coverage. They should continue to have access, but CMS has created a really hard standard, and that I think is the group that I'm the most worried about.
Thank you both. That question is, does this apply to people over the age of 65. I think the lot of people have that, a lot of people, the majority of people over the age of 65 are eligible for Medicare, with the difference to Medicaid.
Go for it.
No, no, you please.
So you deserve an easy one because the answer is no.
No, it doesn't apply. Yeah.
Okay. Yeah, if you're over the age of 65, chances are you're getting Medicare and sometimes Medicaid if you're low income.
And
But
even if
if
you're on,
you're,
sorry, even if you're on both, you're on Medicare and
yeah,
Medicaid, or for some reason just on Medicaid, it doesn't apply to you.
I mean,
okay.
is in the statute itself, it's 19, just anybody over age 64. They're not an applicable individual, so that's a mandatory exemption.
Now here's one was just really tricky. How would it work with impact immigrants and refugees who have legal residency? And
Um,
that may be one that we don't have an answer for, a clear answer for.
I can do my best. I mean, I think that there are in terms of people who are refugees, just remember that this HR1 bill changed, restricted eligibility for a lot of categories. There's a slim group of refugees that are still eligible for Medicaid after this law. So, but legal permanent residents, it's complicated, but people would be enrolled there. But again, I think you have to go through the analysis of how are they enrolled in Medicaid, how are they, what category, and there's different limitations there as well. So it's complicated, but I think that there's many of the same burdens that are on other people. I would say though, also with uh, there's some additional burdens that I'd want to raise up. So work requirements doesn't depend on citizenship or residency status, as I understand it. But uh, there are some uh, like other challenges out there that are worth thinking about. I think that there are people that even if they have a status that allows them to receive Medicaid and work, are concerned about submitting additional information to the federal government because it could end up in the hands of immigration officials, and even if they have not done anything that would be out of line with what they're required to do, it could still be a scary thing there. And then there's certain industries also that rely heavily on immigrant labor that might be particularly hard to document compliance with work requirements. And I'm thinking about farm work here. A lot of farm workers move often, right? So you think about getting mail or electronic communication. I think there's also high rates of chronic illness among farm workers, but they may have less access to healthcare, so more difficulty in documenting it. So and then there's language access issues on top of all of this, right? Like if there's a helpline to call, right, to a center to try to get answers to your questions, if they're not staffing it in different languages, or if the wait time is longer for people that are calling and asking questions in a language other than English, that can be an additional barrier. So again, these are concerns that don't, of course, apply to all people, with legal permanent residence, but it is things that might disproportionately impact that community and create additional barriers to healthcare.
Thank you. How will this, one will state, I'm sorry, begin to send out these notices and do the outreach notice. I know we touched on that briefly before the break, but what sort of timeline and if you need to submit paperwork, will the state notify you if they can't exempt you using the data systems that they have?
So my understanding is that notices need to go out starting in August. Is that, do you agree?
It's 4 months before, is my understanding. So yeah, I think that.
Yeah, yeah. And they should then, in the notices, tell you what you have to do.
I I popped in a resource in the chat. I don't know if we can hand it out, but it does have a chart there. It's that my colleagues made on page and on page 4. It does have a sort of chart of the different kinds of notices people will be getting and information about the timeframes there. Um, uh, I don't know if we're able to, if people can access that, if we're able to share it out afterwards. But um, I, I think we walked through some of those notices and timeframes earlier, but I think it's also can be hard without a visual to sort of map out in your head how it will. So that's why I wanted to share that. Oh no,
It looks like we've lost
we've
Michael.
lost Michael. Uh, that
I-
we could answer some of these that are coming in
Yeah,
the chat if that's okay.
yeah,
Uh,
yeah. I'm looking through the Q&A. Here's a good one. What if you are waiting or appealing a Social Security decision?
I think that's tough. I think first off, I think that there's some in medically in. I think it depends on an individual's personal situation, right, and what is happening while they are appealing. There are some people that would be in this Medicaid expansion population, right, which is the main thing that this will affect. Um, and while they're appealing for SSDI, right? And we know that sometimes it's a long, you get denied initially and it's a long wait process. I think that sometimes people will be getting representation in that process, and it would be important to check in with the person that's representing you as well about any intersections with healthcare and work and compliance, but it may be that you fit into a different specified excluded, you'd be a specified excluded individual. Um, if you have not been determined to meet the SSDI definition of disability. Um, so you might have had your documentation all together in order to do that appeal, and it might be um, important to submit that and see if you might have an exemption from, I'm sorry, the excluded, specified excluded individual from from compliance with the work requirements. There is, I'll stop there. I think that's a particular situation. We've talked a little bit about what if you get those um, uh, 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 benefits, but I think while if you have been denied them and you're appealing, that's a specific situation here.
And thank you, Rashida, for putting some more questions in the chat. So the first one is about Ticket to Work. Um, so we talked about the Medicaid buy-in already, but when talking about Ticket to Work and people using vocational rehabilitation, this is a question that I have been investigating for a few weeks now, because I really wanted to get to the bottom of the answer. And from what I can tell, it depends on your state, unfortunately. I know that's like everyone's least favorite answer when it comes to Medicaid, but it depends on how your state treats vocational rehabilitation when it comes to the Supplemental Nutrition Assistance Program, also known as SNAP. You might hear it called an EBT card. For that program, some of these rules already exist. And your state has already developed definitions, including if vocational rehabilitation qualifies. So it's most likely that your state will do whatever they do for SNAP to this Medicaid work requirement. But a lot of that is very preliminary and just based on sort of the research I've been able to do and Jennifer has helped me with. I also saw questions related to supported employment and other employment programs. And this is a place where I also continue to investigate, and we are urging CMS to provide more clarity because in the rule, they engage in a kind of odd discussion where they talk about how work programs delivered under certain Medicaid programs, if you want to get technical, 1915C and 1915I, supported employment, don't count as work programs. And they also discuss them saying if they're provided under managed care. Okay, well, this is weird for a couple of reasons. One, those programs aren't only delivered under managed care, they're delivered under both what's called managed care and fee for service, which you guys don't need to know. It's like how things get paid for. So why would they only talk about them in one category? The second is that's not a work program, it's work for pay. If you're receiving supported employment, most of the time, not always, you're working for pay. So wouldn't that count as work and not a work program? So I would say the answers there are still, we're still working them out. So I wouldn't say like, yes, they count or no, they don't count. I would say it's something we're really telling CMS they need to be more clear about, and also might be something that your state has to determine. And again, I apologize for how confusing this is.
Thank you, Rachel. Sorry, the internet cut out briefly here, but was able to get back on. Somebody asked about sheltered workshops. Do they count as employment?
So most folks who are working in a sheltered workshop are likely going to be eligible for Medicaid through a pathway that means they don't have to worry about this. Now, America's a big country. There's lots of different, so I'm not going to tell you no person in America because that's a very dangerous thing to say when it comes to Medicaid, but for the most part. Then, as Jen said, then you got to enter this whole analysis of like, okay, do they even have to meet these requirements? Are they excluded? Probably yes. Even if, say, they fell under this requirement, somebody working in a sheltered workshop. Then at the end, let's say they somehow, for some reason, have to meet the requirement. They are working for pay. And there's no like minimum pay requirement. So they should, the hours they work should count as work hours. Jennifer, anything I said wrong?
No, I don't think so. I mean, I think that we've had some questions about what if I make a really low wage? What is this thing that you're talking about with the minimum wage? And just to clarify, it's working, the definition of work is work, one way to comply is 80 hours a month, not no, you know, minimum there of how it doesn't matter if it's low wage work, from my understanding. And then when I said earlier, another way to comply is if you show that you're getting you have the federal minimum wage times 80, right? So right now, I think I said it was $580 a month. In 2026, that'll change as the federal minimum wage changes. But just so people don't get that confused, you don't have to make at least $580 in order to show compliance. It's just another way that you can. You could, maybe you could work less than 80 hours if you are getting $560, earning $80, sorry, a month.
Thank you. Next question. we've heard a lot about that in various resources and different webinars over the past couple of weeks. Would there be an opportunity for self-attestation? In other words, you don't have documentation readily available, but you have a disability. You're pretty sure that you meet one of these exemption categories. Will you be able to sign something that says, yes, I fall under one of these exemption categories?
Do you want to start or should I?
Sure,
Sorry.
sure. So, this is specifically about, can you sign a document certifying, penalty of perjury? I am certifying kind of the way you sign your taxes or something like that, saying I meet these um, requirements, or I have a qualifying disability. The answer is in 2027, so the first year, yes. After the first year, oh my gosh, did I do it wrong? CMS has limited it for certain categories, not at all. And for some categories, you can do it once, what they call per enrollment period, per period of continuous enrollment in Medicaid, um, if you haven't lost coverage in some kind of way. Um, Most of the time, that's going to be when you first apply, most likely. Doesn't have to be, doesn't say that, but it's probably going to be when you first apply. It won't surprise you, we have a lot of concerns with this, mostly because in the law, Congress wrote an allowance for self-attestation, what we're calling signing a document. And CMS has chosen to limit that because they think they can. I don't know.
Yeah, I can drop in here the site if people want to dig right into exactly what CMS says about this here and how they define the individual's period of enrollment and things along those lines. But as Rachel said, it's different depending on what up to the 2027 versus 2028. Uh-oh. I hope Michael didn't freeze again.
I think that's possible, but we've got another question. The same requirements exemptions apply to existing medic. Oh, okay. Sorry, let me restart. This was framed under existing. This was framed under new applicants. Do these same requirements/exemptions apply to existing Medicaid recipients?
Yes.
Yes.
Yes. You will there is a requirement to generally this is to get in the front door and also to continue getting Medicaid. People will have to recertify every 6 months. And the medical, if you have a medical or other special need exemption, that can be for 12 months, but states can choose a shorter period, but they can't. You're going to have to continuously demonstrate this. You can only the maximum that they can do this exclusion specified excluded individuals is for 12 months. And also interesting in the rule, they say that you can only look back to the last 12 months of records there. So there is some more information and details around that, but just so people know, generally this is an ongoing requirement.
Yeah, and that's another place where I am working to emphasize the burden that this places on people with disabilities and serious health issues. You can only have documentation from the past 12 months. Again, with how difficult it is to obtain documentation, how difficult it is to get appointments, arbitrarily limiting that, especially if you have a condition that doesn't change or improve, which is a lot of them. Okay, next question is, how would you show proof if you are in school?
I have to get back to people on that. I'm not quite sure what the databases are that people can query or not. Like that, that's a good question.
Yeah.
I
I
think,
know the
do you know?
rule.
Yeah.
Well, I know what it says, which is that states should be able to pull data from their education agencies and that kind of thing. However, that's not going to apply to everybody. And your state may or may not have that totally worked out. So, for example, enrolled at the University of Washington. Washington State Medicaid should know that you were enrolled at that state school if they have the database set up, which they may or may not have. Then you might have to show something from the University of Washington, get a piece of paper saying that you are, in fact, enrolled. Um, so that's how people would prove it. Hopefully, the state would have your data, but if they don't, you might have to get documentation from the school.
All right, thanks, Rachel. Next question. What about people that don't work 80 hours a month, but they do work, they receive Medicaid funded job posting in order to be successful at work? Right now, there's a Medicaid group called Employed Persons with Disabilities that allows for this. Will people in that group that fall under that category still qualify for Medicaid?
I think we might have touched on this while you were, when you got disconnected, but I think this is similar to Medicaid buy-in programs we were talking about and other things. So I think that the first thing that we need to do is figure out what eligibility category this person is in. And that many people that are receiving in a buy-in program or receiving some sort of job support are in fact not in Medicaid expansion. And then we need to see, it's not simply 80 hours a week. You could be working part-time, but still qualify based on the income that you're receiving. Or, you could be doing a mix of activities and still qualify. So you have to go through that analysis. You also have to go through the analysis of whether or not you have I'm sorry, you're medically frail or have a special medical need that exempts you. So you have to be careful as to how all of these things interact. So try to take the particulars of the person's situation in the state that they're in and walk through that analysis to know whether or not they would be out of compliance with this requirement. There are a lot of different steps there. And again, I hate to say that it's not satisfying because people want to know yes or no, I'm in or out. But this is a complex rule. We are in July after this came out at the beginning of June. And we are all uh, uh, looking at those various situations and seeing how they might play out.
Thank you, John. What makes these work requirements different from the work requirements that we've seen previously? For instance, SNAP, the Supplemental Nutrition Assistance Program, we does have work requirements and has had them for several years now. Is it just the types of eligibility, or is it the way that they're defining disability? What's the difference between, say, these new work requirements for Medicaid and the one for SNAP?
Um, I mean, these are again not the. I think that's states have implemented these SNAP work requirements before. They're not the same requirements. The laws are different. Um, and there are some charts. There are people who are experts in both of these that have crosswalked them. I can drop a chart. I can drop an article in the chat if people would like to dig into it. But and that's just one of many. There are a number of people who are crosswalking them and seeing how states can use the systems that they already have to try to, see who's compliant. It's addressed a little bit in the statutory language of this law of people who are already subject to SNAP work requirements, but are not people who are in a. I want to get it right. People who are in a household that is required to comply with the work requirements, but are in compliance. I apologize. I'm trying to quote something off the top of my head, which I should not do. But my point is that there are intersections between these two laws, and there are people who are mapping those intersections, but it's pretty complicated. You can't just say these are the same. There are differences between them because you are have to comply with one, you have to comply with the other, or vice versa. And that's
Yes.
about as I'm sorry, that's about as much as I can share without being a SNAP expert and getting myself into trouble.
In some of it, they try to mirror what's in SNAP. For example, the definition of a work program, but also some of it they don't. So again, it's the kind of thing where it's really difficult to give an answer of saying, yes, it's the same, or no, it's different.
Thank you. The next question is, how did this IFR increase the state administrative burden, and what is going to be the effect on the capacity of state Medicaid programs? And then the second part of that question, will the state disability determination services, will they be involved in any way in making the determinations?
So I can start with the first one, which is yes, the administrative burden on states will be very large. That is why so many of them are suing the federal government, and that's one of the big things they say in their lawsuit. Um, that this is different than what Congress put in the law. They were already on a really tight time frame. They don't have the time or money or staff to build up the systems that are required to implement this program. So the administrative burden will be huge. Um, on state disability determination services, the question is, will they be included? Not officially. Officially, they work in the Social Security system. Unless your state is doing something that I'm unaware of, again, it's really hard to make declarative statements in this kind of program, but not officially. However, more people may end up seeking a Social Security disability determination because it is now more necessary in order to keep their Medicaid. That could be a sort of behavioral change that we see. Those services are already incredibly backed up. There is a very long wait to get your disability determination. It's very difficult to get information out of them. And so that could also be another consequence, is that those offices get even more um, overburdened.
Thank you so much for that. We are almost at the end of our time here, and I wanted to start by thanking both Jennifer and Rachel so very much for the time this afternoon, and also apologize for the technical difficulties. We did get an overwhelming number of questions, and we tried to get to as many of them as we can. One we send out the follow-up email with the recording. We will also include an email with the policy at aapd.com. If somebody could put that in the chat, policy at aapd.com. If you email the question to us, we will try our very best to get you an answer. I also wanted to point out that we have already put out one resource, the Medicaid Work Requirements FAQ document that came out on our website a couple weeks ago. And if you were on our email list, you should have received that document that will cover a lot of the questions that people may have. One thing that is very important to note, I know I mentioned this in the first half of our webinar, the email for you to submit comments to CMS on this interim final rule, the action alert that I talked about earlier, that will be going out via email this afternoon to everyone on our email list. If you were not signed up for our email list, go to aapd.com. There is a link to sign up for updates and emails. We try not to send more than a few a week, but it's a good way to keep in touch and keep up with what is going on in the disability policy world. We also have plans to publish more than a dozen explainers and resources between now and the end of the year to help people understand what these new work requirements are, who's exempt, how to prove that they qualify for an exemption. So if you didn't get your question answered today and you don't feel like emailing it, chances are that we will be putting out a resource in the coming weeks and months that will address the question. And lastly, we have a page on our website, a Medicaid Defense Hub, which is at aapd.com/Medicaid. All future Medicaid work requirements that I just said that we will be releasing in the coming weeks and months, those will all be available on that page. So again, aapd.com/Medicaid. And once again, thank you all very, very much for joining us. Thank you also to our wonderful panelists, as well as our interpreters and our cart captainers. and stay tuned for more information. This is not a one and done thing. So we will be providing much more information so that this does not fall off of people's radars between now and the end of the year, because January 1 will be here before we know it. So have a wonderful rest of your day and stay cool.